This is obviously insane. If they want to delete a website, take it off the website, they can take it off the website. So it's micromanaging by the judiciary. This judge is running out with like 3 TVs right now. There's a reason why this president fired him. Maybe the president knows something this judge doesn't know. Maybe the president has a national security concern after he got into office and saw all of it. And this judge turns his emails back on. President Trump is striking back, appealing these judges' orders. This is some group called Doctors for America that sued the Office of Personnel Management. These doctors like, well, we needed a website on there because we needed to look at it. So they say upon consideration of the motion, this goes right to the judge, filed, judge comes back out. They say it is now granted. These doctors beat with one motion the Office of Personnel Management, right? It's like, what? Here's what the judge says. Department of Health and Human Services and the CDC and the FDA shall, by the end of business today, okay, this is the judge, restore their versions of the January 30th web page and data set. Put your websites back on the internet. And Trump and the administration shall identify other resources that they rely on to provide medical care, saying they took their websites down. The doctor's like, no, we need those websites up. We go there and we have to pull our information from whatever. Say they didn't get notice or explanation, and they shall restore those resources to their versions as of January 30th. But the parties shall, not by later than February 13th, submit a joint status report so ordered by the judge. No rationale, no other explanation. It's a 2-page order, and that's what we got. So this judge is now in charge of the IT department for HHS, the judiciary is. Now we add all of these up, right? This is obviously insane. If they want to delete a website, take it off the website, they can take it off the website. So it's micromanaging by the judiciary. This judge is running out with like 3 TVs right now, like 3 TVs. Judge, that's a little excessive, even for theft from the federal government, but he's doing it anyways. With that in mind, let's take a look at what's happening in the actual battle over this special counsel. Hampton Dellinger was fired by President Trump, and then he sued. He says, you can't fire me. Who do you think you are? Like the president of the country? This is in the District Court of Appeals for the DC Circuit, and you can see it's an emergency motion for a stay. In other words, don't make us hire this guy back, Court of Appeals, because Amy Berman Jackson is crazy. Here they write, all right, listen, we know who the people are in this case. Plaintiff is Hampton Dellinger. The defendants are the entire federal government that Hampton sued over. The ruling under review is now coming up, and here is the memo. They say, all right, listen, Court of Appeals in DC, this appeal arises from an administrative stay entered by the lower court, Amy, ordering the immediate reinstatement of a principal officer of the United States whom the president has lawfully relieved of duties, aka fired. Now, given the grave harm to the separation of powers, the district court's order works. The government seeks a stay of the order pending disposition of this appeal, so don't impose it now. Now, the Supreme Court has made clear twice and recently, actually, that Article 2 precludes Congress, and Article 2 governs the executive branch, right? Article 1 is the legislature, 2 is the executive, 3 is the courts. So the Supreme Court has weighed in and said the Constitution stops Congress from limiting the president's authority to remove principal officers of the United States who serve as sole heads of an executive agency, citing 2 cases, Collins versus Yellen and Seila Law versus the CFBP. Same thing, right? In Seila Law, the court invalidated the restrictions on removing the head of the CFBP. And this is what Pocahontas has been screeching about over the last 3 days. Now, and in Collins, in that case, the court explained that Seila Law was all but dispositive. In other words, they tried to stop the firing of the CFPB except for like good cause. You can only fire this person for good cause or whatever. Like, what? We're the president. You don't get to dictate how we fire somebody. The president is the root. You don't get to usurp his powers and put somebody over him and shackle him. So consistent with those holdings, Biden exercised his constitutional authority to remove the commissioner of Social Security in 2021. He did that. The only courts of appeals to have addressed this have sustained it, by the way. And so in this case, the president exercised the exact same authority in Seila and in Collins, and he's doing the exact same thing as President Biden did. And he removed Hampton Dellinger as the head of the OSC, which is an executive agency branch. It has a single head, just like CFPB, just like FHFA, just like Social Security. So he is fired. This should not have been a constitutionally controversial act, Judge. Dellinger's removal was consistent with a long-standing executive branch view dating back to the creation of the OSC during the Carter administration that removal protections for special counsel are constitutionally dubious, all right? Because there is no special counsel branch, right, in the Constitution. The Supreme Court recently noted the lack of historical precedent for their removal protections, describing the OSC as a novelty. They say they created that nearly 200 years after the Constitution because they hate the Constitution. They're like, let's improve it, idiots. Even though no other enduring single leader office has been established during that time, and noted that it drew a contemporary extemporaneous constitutional objection from the OLC even under Carter. And in the Collins case, when the government argued to the Supreme Court that the director must be removable under SELA, it noted that the same would be true of the special counsel. But in this district court, Amy Berman Jackson in the DC Circuit, just hours after Dellinger brought this suit, right? In other words, they're saying, look how obvious this is. Even a moron judge could figure this out. Says just hours after Dellinger brought this suit to challenge his removal, and before the government had even the opportunity to respond to his motion for a TRO, issued what it characterized as, quote, an administrative stay, just pulled it out of her booty, restoring Dellinger to the office. No, you're hired again, I decided. Enjoining any efforts to stop him from accessing the resources or materials of that office, right? Notwithstanding the district court's attempt to frame it as a modest thing, this order is extraordinary. It's unprecedented. It is an intrusion into the president's authority to exercise all of the executive power of the United States under SELA law. Now, the government is unaware of any other occasion in American history where a federal court has purported to reinstall a principal officer of the United States after the president has removed him, let alone to do so without finding that he was likely to prevail on the merits of his claim, as the district court did here. Like, you're wrong on the law and you just shoved him back in there for whatever reason so he could delete his emails. Indeed, even if the reinstatement were a permissible remedy for an unlawful removal, the district court gravely erred in ordering that remedy on an interim basis, given the absence of any irreparable harm to Dellinger, all right, on the one hand, and the potential disruption and damage to the executive branch functions resulting from a judicially compelled reinstatement of a principal office of the United States over the objection of the president that the entire country elected. This judge was appointed by another president and confirmed by the Senate. Great. Trump was elected by the entire country, and this Treasury, Scott Bessent, was also nominated and confirmed by the Senate. So we've got two branches of government and the back of the American people, and this judge has decided, F you, I don't care, take him back. This is not merely an abstract interference with our prerogatives, but it involves compelling the government to provide access, oh, they got it, to investigative files, right? There's a reason why this president fired him. Maybe the president knows something this judge doesn't know. Maybe the president has a national security concern after he got into office and saw all of it. And this judge turns his emails back on so he can download the nuclear bomb CAD files while impeding the right to acting special counsel from faithfully executing the laws, right? And she usurped his power. This is maybe a co-conspiracy to get him access to his emails. What did he do? We should see what that is. I hope the DOJ is looking into that. What did this guy do? When he logged in to back, he's got on his Outlook, he's like, oh, perfect. He goes back to this folder, looks up, search, John Podesta, delete. John Brennan, delete. Mark Milley, delete. All right, good. I'm good, Judge. The court should stay the district court's order and should grant an immediate stay, talking to the Court of Appeals, pending consideration of this motion. Now, in the alternative, to the extent this court harbors doubt about its jurisdiction, it should treat this motion as a petition for a writ of mandamus and grant this now. So they're like, look, we're appealing an administrative stay. They might say we can't appeal an administrative stay. That's fine. Then we're take this as a writ of mandamus. I don't care. Just take it. You have the right. Here's your jurisdiction. Pick one of the two. So here's the background. They say Congress created the Office of the Special Counsel back in 1978. The act authorized the special counsel to receive and investigate any allegation of a prohibited personnel practice and to request corrective action. Now, from the beginning, the executive branch objected to the constitutionality of the removal restriction, saying, according to Congress, right, it says the act provided that special counsel could be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. And that was rejected when it came to the SELA case, as I'm sure they'll explain. Now, in a published opinion, the Carter administration, OLC, said because the special counsel would be performing largely executive functions, Congress can't restrict the powers president to remove him. He doesn't get to be his own branch of government. And when Congress passed an initial version of this that separated OSC out, Reagan vetoed that, saying, nope, it's unconstitutional, you can't do it. Congress ultimately passed a revised version of the Whistleblower Protection Act that separated the OSC from the board, removed certain additional powers as well. Bush signed that bill, but the executive branch did not recede from its objection. They've been objecting to this the entire time. Even Bush objected. OLC advised Clinton even that the Social Security Administration's new structure as an agency led by a single person was extraordinary, and there's other constitutional questions there about Social Security if you can't remove the person. Now, today, the OSC exercises the same powers as it did before. It's vested with an array of executive powers. Their responsibility includes all sorts of stuff, and so that's where we're at. Now, this case was brought about by Hampton Dellinger, was appointed by Biden, and was confirmed by the Senate to serve as special counsel beginning March 2024. On February 7th, Director of the White House Personnel informed Dellinger, "You're fired. Get out, effective immediately." Then yesterday, they say, Dellinger brought this suit to challenge his removal, moved for a TRO. Upon receiving the motion, the court set a basically immediate hearing. Okay, let's hear. Before the government had even responded. Several hours later, the court entered what it described as a, quote, "a brief administrative stay to preserve the status quo." So this guy could access his emails, and I hope they tracked every single mouse movement, every single keystroke. The court's order restored Dellinger to the OSC and said give him access to his files. The government filed a notice of appeal immediately and a motion to stay the district court's order. The district court has not ruled on the motion, and if so, we'll let you know, Court of Appeals. Now, Your Honor, we're going to win on this, okay? The OSC is an executive branch agency. As described above, from the time it was created, all the administrations had doubts as to whether Congress can stop a president from controlling his branch. Over the past 5 years, the Supreme Court has definitively resolved that question in the negative. Officials vested with sole responsibility for overseeing the exercise of executive powers must be directly answerable to the president. Now, and I know what they're going to say already. They're going to say that there is an exception for special counsels. That will be the response. But Article 2 of the Constitution provides that the executive power is vested in a president that must take care, capital C, care. It doesn't mean you just take care and do whatever the Congress wants you to do. You got to actually have some execution and discretion in the execution of the law. And you have to do it for the care of the country. Sending money to foreign countries with no clear connection to American interests is not taking care of the nation. To discharge those responsibilities, the president, as a general matter, has the authority to remove those who assist him. Without this power, the president could not be held fully accountable. The buck would stop with someone else. Constitution says that, right? The Article 2 vests it in a sole president, not a president plus a special counsel. The Supreme Court has recognized only two exceptions. First, in the Humphreys case, the court held that Congress could give for-cause removal protections to a multi-member body of experts. This was a 1935 case, balanced along partisan lines, that performed legislative and judicial functions and was said not to exercise any executive power. It's like, okay, so they just made that up. The courts did. And then second, the court has held that Congress could provide tenure protections to certain inferior officers with narrowly defined duties, okay, if it's a lower level office. But the special counsel does not fit within either of these exceptions. He is not an inferior officer with narrowly defined duties. He's a principal officer appointed by the president with Senate confirmation. He oversees his own department and is not subservient to any other principal officer, anyone else. Nor does the special counsel work as a multi-member expert agency. 5 years ago, the Supreme Court surveyed the executive branch and identified only 4 then existing examples of single-member agencies who were afforded protection against at-will removal. As described below, the Supreme Court has now itself invalidated the removal protection for 2 of those agencies, right? The CFPB and the FHFA. So this one also should go. The Office of Legal Counsel and 2 courts of appeals have concluded that the removal protections for a third are likewise invalid for the Social Security. So now special counsel is the 4th. Get ready, it's coming. Here's why. In SELA law, a prior case, the Supreme Court invalidated the removal restrictions of the director of the CFPB. This is Elizabeth Warren's little scam organization that was harassing everybody for the last several years. And Congress, they passed it and said, you cannot remove her or the leader of that organization. This case addressed that, says, yes, you can. The single director structure, they wrote, contravenes the Constitution. It's a carefully calibrated system of vesting significant governmental power in the hands of a single individual accountable to no one. If you were to do it that way, it contravenes that. When the founders chose to vest executive authority in a single person, that's the president, the court explained they ensured that the president would be the most democratic and politically accountable official in the government elected by the entire nation. Thus, while executive officers assist the president, they remain subject to the president. The director could originally unilaterally, without meaningful supervision, do a bunch of stuff. And the president, under the rules that Congress passed, right? Congress tried to constrain the president, said that you could only remove that person for inefficiency, neglect of duty, or malfeasance. Otherwise, they're yours for life. Eat it. Court said that is unconstitutional. The Supreme Court said that. It's not an old case, the SELA law case. It's relatively new. Concluding, principal officers who are acting alone wield significant power. They're removable at will by the president. And this lower court judge knows that. The Supreme Court applied the same logic when it invalidated the for-cause removal of FHSA. They said, yeah, it's the same concept. So in the wake of these, Biden then kicked out the Social Security person without cause, contrary to the statutory limitations on that person. And the Department of Justice explained it. They said, hey, we're just following Supreme Court law. It said that the president doesn't need to heed any tenure protection, doesn't need to follow those limitations that the Congress sets on the executive. The only courts of appeals to have considered these, the 9th and the 11th, have both concluded concluded that the restrictions that limit the removal of someone are unconstitutional. And so guess what? Office of Special Counsel is indistinguishable from those other cases. There's no doubt that this person exercises executive authority. They can investigate anyone, bring actions, they can intervene, they can appoint, they can prescribe, they can do amicus, they can do core. All of these are core executive functions, and they're doing it. The exercise of those duties implicates the faithful execution of federal law, and that's what we're doing now. Now, if that were not enough to give Trump the authority to fire this dude like it ain't nothing, shouldn't even have to think about it. Dellinger is deeply mistaken in seeking judicial reinstatement. When principal officers have been removed, they have challenged removal in suits for back pay and many other things. But the president, judge, cannot be compelled to retain the services of an officer whom he believes is no longer to be entrusted with the operation of the executive power. Such a remedy would undermine the Supreme Court law and the entire functions of the executive branch. So, Court of Appeals, we request a stay on this. As discussed above, this is going to cause serious harm to the president, and it's in violation of the Supreme Court. Because of that order, a person the president has chosen to remove is exercising executive power over the president's objection by shoving him back in there. And Dellinger is not going to have any harm because the government, they say loss of income or reputation is not some extraordinary circumstance. If he says there's irreparable harm, he can go get another job. His reputation, he's not entitled to work for the government forever. Go get a different job. And by the way, this is harming the acting special counsel who already came in to clean up this dude's mess. And by the way, you have jurisdiction over this. You know you do. Federal rules of procedure say all the following. And so hear this case on this, although not ordinarily people, they're appealable when they're more akin to a preliminary injunctive relief. That's what they're asking for. So the Court of Appeals has issued a response, and here is the order. As we can see, it says, filed February 11th. The case is Hampton, the special counsel who got fired. They're telling us, upon consideration, it is ordered that the appellee file a response to the emergency motion by 9 a.m. on February tomorrow. Any reply is due by noon tomorrow. Awesome. All right. So the Court of Appeals is considering it. They're hearing it, and they're probably like, there's a lot of case law that goes in Trump's favor. So you can see how this is getting more and more ridiculous by the day. It's like the judge came out with one TV on the first day. Then like he told his friends, man, you can just go in there and just take TVs. Like no one cares. Like actually it's illegal, but whatever. Everybody's running out with TVs now. So the judge just granted this dude, and it is strange, right? How she just give him his access back like immediately.